You're listening to continuing coverage in the suitcase murder, the trial of Sarah Boone, from the Hidden Killers podcast and True Crime Today. Now, back to the courtroom.
The language in the instruction in pertinent part says he or she was committing an act, insert the defendant's criminal activity that the defendant but the criminal activity cannot be the charged crimes for which the defendant is claiming self-defense or the defense of others. The charged crime, second-degree murder. So I'm struggling with understanding as the other crime is, because I'm not hearing any argument as to the applicability of aggravated assault.
Judge, because, and I didn't make any argument about aggravated assault applying because they can't get over the first hurdle. The first hurdle is it has to be charged. It's not charged. That's what the case law says. I mean, this is pretty clear to me unless I'm looking at it wrong when it says this is not to be given if there isn't an independent forcible felony charged.
Any other response, State?
Just that it defeats the purpose of the statute and is manifestly unjust when it is a legal technicality of no import. There is no interlocking verdict required. If we were able to charge aggravated assault, there's no requirement that they both be found guilty. They could go ahead and hear this instruction and find her not guilty of aggravated assault and still convict her of second-degree murder because of all the plethora of permutations we have in these instructions.
But in Martinez, the underlying charge was attempted murder and aggravated battery, both of which were charged, and we don't have that here.
But it's still going to the one act and those facts. We are talking about separate, clearly distinct facts here that support there's an aggravated assault that separately gets committed first, and then in response to the victim responding to that aggravated assault, she leaves him in the chokehold to die because if she lets him out, it's her belief she's going to face death or great bodily harm because she committed a forcible felony against him. This is purely a legal technicality. The entire opinion on Martinez, until the very last paragraph, uses this language. They use language like, the underlying facts of the present case demonstrate why it would be illogical to conclude that section 776041(1) applies where there is no independent forcible felony. It doesn't say where there is no independent forcible felony charged. It goes on and uses that same language all throughout the opinion, and then in the very last paragraph in the conclusion, it changes to, in conclusion, we hold that it is error for a trial court to read the forcible felony instruction to the jury where the defendant is not charged with an independent forcible felony. But there is an independent forcible felony in the facts. There is a statute that says that Ms. Boone should not be able to avoid the girth of this jury instruction. She violated, according to the facts that she gave us, she violated 776041(1). She was committing an independent forcible felony and therefore should not be able to get away with this instruction not being given because the technicality that the state can't charge a case or can't charge a count that is not required to be interlocked by verdict. Thank you.
Okay. Footnote 4 provides, explanation in the Martinez opinion as to certain circumstances and whether or not in that hypothetical that the Supreme Court gave, whether the robbery is a separate and independent forcible felony and the forcible felony instruction is applicable. But the conclusion seems to state that it has to be charged, that it is an error for the trial court to read the forcible felony instruction to the jury where the defendant is not charged with the independent forcible felony. Anything else, Mr. J?
No, sir.
Then how do we want to accomplish this? Because I don't know how I can read the proposed language by the state, and there's a disagreement as to whether there's a duty to retreat. And it's not undisputed. It is, in fact, disputed.
Well, their complaint is in the sentence, on the other hand, if at the time Sarah Boone used deadly force, she was, then I just think you strike, we strike through committing an aggravated assault. We go to, if at the time Sarah Boone used the deadly force. Okay.
And unless you just want to go to 2, on the other hand, if at the time defendant used deadly force, she was not in a place where she had a right to be, then the defendant had an obligation to, then the defendant had a duty to retreat, just excise 1 completely. I don't know what else to do.
Well, she has a right to be there.
Right, under the Castle Doctrine and the case law.
Okay, then I think we go with the first paragraph and then we just deal with the initial aggressor at the end, which is kind of the exception to that. So,
Okay, so then Sarah Boone had no duty to retreat before using deadly force.
Yes.
Okay, is that acceptable to the defense?
Yes.
I think it puts us back in the position where we started at anyway.
Yes.
Okay, all right.
I just object for the record in case some assistant attorney general wants to potentially cross-appeal something.
Objection noted. It looks like the next parts of the form instruction, if the defendant was in a dwelling, was excised, the give A, B, or C was excised. Are you on board with that state?
Yes, sir.
Then the next paragraph, a person is not justified in using force to resist an arrest. Clearly, that's not applicable. I don't think that's at odds. However, if an officer used excessive, I also don't believe that's applicable based on the facts. We then proceed to the give in all cases language. Any objection to this language state?
Just kidding.
Sure. It's the bottom of page 2 of the defendant's 3.6F red line.
I'm just finding where it's in
On the form instruction, it's the bottom of page 3 of 7. Give in all cases, right after Jackson v. State.
Yeah, just the agreed upon strike-throughs of or threatened use. So just being deciding whether Sarah Boone was justified in the use of deadly force, you must consider the circumstances at the time.
Any objection?
No objection to that, Judge.
Okay. We'll excise the threatened use, so it'll all read use of deadly force in that paragraph. All right. Now we have a proposed instruction, I believe from the defense regarding battered spouse.
We table the battered spouse proposed instruction since both parties have that?
Sure. Moving now to the presumption of fear, that's been struck out by both parties and agreed to. Moving to the exceptions of presumption of fear, that's been struck out by both parties and not necessary. That takes us to a person who unlawfully by force enters or attempts to enter, that's not applicable. Definition of dwelling is not applicable. Residence and vehicle are not applicable. That takes us now to the aggressor language.
No additional arguments as to why the facts show she was the initial aggressor, and thankfully for the state, there's no requirement under this provision that there be an independent forcible felony.
Okay. Looks like we have a disagreement between the parties as to the application of the aggressor instruction. It's struck out on the defense's side and not in the state side. What say you, Mr. Henderson?
Give me 1 second.
Sure.
Please.
Yes, sir.
All right, are we on 776.041 sub 2?
Yes, sir.
Okay. If I could have one more.
Yes, sir.
Judge, my argument would be that the only evidence, well, the evidence from Sarah Boone stated that she did not do anything forcefully wise until after Mr. Torres had made verbal threats and was coming out of the suitcase. So that's my objection is based on that. No other legal argument.
Any other argument, state?
Just judge, it's play wrestling and not releasing the chokehold when your buddy tapped out.
And, I mean, isn't there evidence as to what Ms. Boone had told the experts, which seems to be at odds with that issue, and it's really a factual issue and a determination for the jury to make that determination on what the real facts are?
I can't disagree with that.
Okay. Then with regard to the proposed language as the 776.041 sub 2 instruction, however, the use of deadly force is not justified if you find that Sarah Boone was attempting to committing, or escaping after the commission of aggravated assault. An aggravated assault is defined.
No.
No?
That's the friend one.
Yes.
Am I on the wrong section? I apologize. I am at the wrong section. Forgive me. So it is the However,
With my strike-throughs, it's however the use of deadly force
is not justified if you find that Sarah Boone used force to initially provoke the threatened use of force against herself unless, one, the threat of force asserted towards the defendant was so great that she reasonably believed that she was in imminent danger of death or great bodily harm and had exhausted every reasonable means to escape the danger other than using deadly force on George, that's spelt incorrectly, Torres, or two, in good faith, Sarah Boone withdrew from physical contact with George Torres as clearly indicated to George Torres that she wanted to withdraw and stop the use of deadly force, but George Torres continued or resumed threatened use of force.
Yes, sir.
What's your, just for clarification purposes, anything else as to that instruction, defense?
Just one thing I need to put on the record, Judge.
Yes, sir.
The force at that time, as testified to, was the poking of the bat on the outside of the suitcase. There was one strike when the hand was outside. These were bruises. I think there was something that came to the injury to the head area, though. The injury to the head could be serious, but in this instruction, it's talking about deadly force. And none of those, as to the testimony from the medical examiner, none of those injuries caused the death.
Judge, the continued restraint on him that she did not undo is the force that we're talking about. It's just like in the cases that I cited in my special state's request for special jury instruction regarding withdrawing from physical contact. Batteries don't need to be skin to skin. You can commit a battery on somebody while driving your car and striking their car. A false imprisonment does not mean you have to choke somebody. You can falsely imprison somebody by barricading them into a room with a grocery cart. She unlawfully exerted that force and did not withdraw from using that force when her wrestling partner, so to speak, tapped out.
Okay. I'm going to include the instruction for now. The next paragraph reads, if you find that Sarah Boone, who, because of prior threats or difficulties,
No objection to the statement.
all right, that'll be included. The next paragraph, if you find that at the time of the alleged aggravated assault and or criminal mischief.
Yeah, there just needs to be secondary murder, manslaughter, or culpable negligence, and we don't object. There were specific acts put in evidence.
Any objection to changing the beginning of that sentence, defense, if you find that at the time of the alleged murder in the second degree, manslaughter, culpable negligence, Sarah Boone knew that George Torres had committed an act?
Yes.
Okay, thank you.
And we requested the strike through at the end or threatened to use.
Agreed.
Give me a moment. So that sentence would now, or that section would now read, if you find that at the time of the alleged second degree murder, manslaughter, or culpable negligence, Sarah Boone knew that George Torres Jr. had committed an act or acts of violence, you may consider that fact in determining whether Sarah Boone reasonably believed it was necessary for her to use deadly force. Acceptable?
Yes, sir. I just don't know that we use Junior after his name anywhere else.
Give me a moment. Yeah, Junior's not used anywhere else, so I'll excise that. Is that acceptable to you, Mr. Henderson?
Yes, Your Honor.
All right, moving to the next line. If you consider that George Torres, removing Junior, had a reputation for being a violent and dangerous person. I don't know, did we hear evidence of reputation?
The state's position is going to be there was no reputation evidence. Ms. Boone offered an opinion, but as everybody knows, reputation evidence has to come from a broad enough aspect of the community, whether it be a church or a neighborhood or perhaps even a large family. But
Defense?
I'm rethinking that, Judge.
No worries, take your time.
I know generally, and reputation evidence generally, it has to be something that is known based on a community standard, and if that was the community. I know the only thing that I can relate to is the fact that individually she experienced certain things that could build that reputation, but that's unheard. I think there's evidence, though, from people, at least that they knew about it or were told about it. Most of that was stopped. But I could go to at least the one situation on a text message that was introduced earlier today that talked about him beating his former wife or ex-wife.
How's that reputation? That sounds like that's a specific instance based on that text message.
Correct. I agree.
Okay, so in agreeing, we're going to excise the reputation section, correct? Okay, thank you. The court will excise that.
State agrees to the physical abilities that's mandatory in each case.
What about the one that precedes that? If you find that George Torres had a reputation, well, also that reputation would be removed as well, correct, Mr. Henderson? If you find that George Torres Jr. had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor.
That's correct.
Okay, so that'll be excised as well. State has no objection to the physical ability section. I'll just remove the word junior after Torres. Any other questions with regard to the 3.6F instruction?
Your Honor, State doesn't object to what we have produced as the final product. I'm impressed we did it so quickly. We just note our objection for the record to preserve a challenge to Martinez's opinion.
Understood. Do the parties, well, let me ask this question. Mr. Henderson, anything else we need to address with regard to the 3.6F instruction?
No, sir, I'd just like to preserve the objections that I made during this conference.
Objections preserved. Do the parties wish the court to reread the 3.6F instruction that we just went through, just to make sure we're all on the same page?
Yes, sir.
Can we do it at a time where it
Is in final form? Yeah,
Yes.
absolutely. Okay.
Perhaps a written copy that we can take during snack time.
Sure, absolutely. All right. Where does that take us now? Does that take us to the 3.6G instruction?
I believe so.
Okay, give me a moment. I have the state's proposed 3G instruction. I have the form instruction from the Supreme Court. And I have the defense's proposed revisions. Just move everything around here. Give me a second. Okay. All right. As to the title, I believe that based on what we've discussed, the "or threatened use" should be removed. Is that correct?
That's correct.
All right. As to the first sentence, it is a defense to the crimes of second-degree murder and culpable negligence if the actions of Sarah Boone constituted the justifiable use of threatened use, as we're removing justifiable use of non-deadly force. Would we be removing threatening, and we would also be including manslaughter, correct?
That's correct.
State?
Yes, sir. It is a defense to the crime of second-degree murder, manslaughter, in Oxford, or culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force.
I too am a big fan of the Oxford comma. So the defense would, or the instruction would now read, it is a defense to the crimes of second-degree murder, comma, manslaughter, comma, and culpable negligence if the actions of Sarah Boone constituted the justifiable use of non-deadly force. Acceptable state.
Yes, sir.
Acceptable defense.
Yes, Your Honor.
Definition of non-deadly force is not at issue. Next paragraph. Sarah Boone does not have the burden of proving that she was justified in using non-deadly force. Instead, for you to find Sarah Boone guilty, the state must prove beyond a reasonable doubt that Sarah Boone was not justified in using non-deadly force. Acceptable state.
Yes, sir.
Defense.
Yes, Your Honor.
The law on justifiable use of non-deadly force is as follows. Sarah Boone was justified in using non-deadly force against Jorge Torres, excising Jr., and had no duty to retreat if she reasonably believed that such conduct was necessary to defend herself against A, Jorge Torres, excising Jr., imminent use of unlawful force. Is that instruction acceptable?
Yes, sir. I don't know if you mean to include the A if we're not using the B. I would just suggest you make one sentence.
Any objection?
No objection.
Okay. Any other issues with the instruction as read so far? State.
No, sir. Thank you.
Defense.
None, Your Honor.
Okay. Looks like there are several agreements with the balance of this instruction as to the defense of property is not applicable, the 776.0134 dwelling and residence and vehicle, and force with regard to law enforcement, all of which is not applicable in the instant case. That takes us to the give in all cases. We would be removing the threatened use of non-deadly force in that section. Any other changes is to the give in all cases section.
Not from the state. Thank you.
Defense.
None, Judge. No objection.
Okay. Let's table the proposed instruction on the battered spouse for the moment.
Then the state will be making its request for the forcible felony instruction.
Under Martinez.
Yes, and we understand the court's ruling, and we're sending a strongly worded disagreement to the Court of Supreme Court.
Received and understood, but based on what the court said earlier as to the conclusion in the Martinez section, I'm disinclined to add your proposed instruction.
I understand why.
That takes us now to the 776.0412 section. Looks like we have a little bit of a disagreement here. Is it the same arguments that we received in the 3.6F instruction?
It's the same fact.
Any other additional arguments, sir?
No, Your Honor.
All right, for the reasons previously identified, the court will accept the state's proposed portion as to the 776.0412 instruction. Then it takes us to the prior threats.
Same requests and objections as in 3.6F from the state, sir. For the end of the instruction.
I agree that it should track with the,
Forgive me. Other than reputation, what were the other issues?
Prior threats should come in. Specific acts should come in.
Okay, thank you. Reputation should be excised.
The two paragraphs of reputation excised, and then physical abilities gets read in all cases.
Agreed?
correct.
Okay,
Agree.
all right. And then we'll remove the threaten language in there, correct?
Yes,
That's correct.
Give me a moment. Okay. Any other questions with regard to the 3.6G instruction state?
No, thank you, sir.
Defense?
None, Your Honor.
Okay. I believe then double check my notes. I believe then that addresses those issues based on what we did not discuss this morning in the charging conference. And I think that now takes us to the state's requests and the defense's request for special instructions.
Can we do the battered spouse one first, since we have conflicting requests?
Yes. Specifically, we're making reference to the state's request for special jury instruction regarding battered spouse syndrome filed, I believe it's not dated, but I think it was either the 23rd or the 24th that you filed these, Mr. J, and the court record will speak for itself as to when they were filed.
Speak the 23rd.
Okay. Courts reviewed that motion and reviewed the proposed instruction by the defense. State, let me hear from you first.
With their instruction, I think the problem with it is that it kind of blurs the subjectivity component versus the objective reasonable person standard. So if we make this change to their instruction, then I'm actually okay with it. What I would suggest that change be is in the second paragraph. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by the victim, No Jr. I don't know what's necessary with the date. That makes it clear, because that's what the case law says. The case law makes it very clear it's about the objective component.
I agree with you.
And then I would just ask for my last sentence, which is, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse.
What say the defense? And if necessary, I can read.
Yes, could you do that?
So it looks like there's no, first of all, just so the record's very clear, Stevens v. State identifies the special instruction circumstances. Special instruction is supported by the evidence in this case. Yes, absolutely. The standard instruction did not adequately cover the legal theory it is meant to. There is no standard instruction on battered spouse over and above what's included in the self-defense instruction. The special instruction was a correct statement of law and not misleading or confusing. We're addressing that third prong of Stevens at this time. The proposed instruction would read, you have heard evidence that Sarah Boone suffers from battered spouse syndrome. If you find the evidence that Sarah Boone suffers from battered spouse syndrome credible, you may consider this evidence to assist you in determining whether a person in Sarah Boone's circumstances would reasonably believe that such force was necessary to defend herself against the imminent use of unlawful force by Jorge Torres. It would then go on to read, like other witnesses, you may believe or disbelieve all or any part of the testimony regarding battered spouse syndrome.
Agreeable.
Okay. Appreciate y'all working together on that. Give me a moment to finalize this. As such, the third prong of Stevens has been made, and the court will give the special instruction as identified on the record. Now, the only question I also have is, do we want this as its own instruction, or do we want this included where it currently is in the 3.6F and 3.6G instruction? State.
I would suggest it be 3.65, right after the two instructions about use of force.
I agree with that.
Okay. Do we want to label it or just have it as special instruction and then read it? Do we want to have the title special instruction on battered spouse? I welcome.
I'm fine with you just saying battered spouse syndrome.
That's fine.
Okay, so it'll be special instruction on battered spouse syndrome. Is that acceptable?
Yes, sir.
Is that acceptable?
Yes, sir.
All right, thank you. All right. And that will follow after the 3.6G instruction, correct?
Yes, sir.
Acceptable?
Yes.
Mr. Henderson?
Yes, sir.
All right, that takes care of that.
All that should be left.
Yes, I'm sorry, sir.
I'm sorry. I think we might be required to read it both times, after each one.
I have no problem with adding a paragraph into it that says this applies to both the justifiable use of deadly force and non-deadly force.
That fixes it.
Okay. Where, gentlemen, do you want that?
After the big paragraph that ends with Jorge Torres and before like any other witness.
Sure. Okay, so let's go over that language one more time so that we're all on the same page. Mr. J, what is it that you proposed?
To put between the paragraph that ends with Jorge Torres and before the paragraph of like other witnesses or whatever I said, you can consider this testimony and evidence in the applicability or the use of whatever word people agree on of both deadly force and non-deadly force instructions, something to that effect. If that's too convoluted, I'm fine with it just being repeated.
I tell you what, I'd rather just repeat it.
I think so.
That gets way complicated. I'd rather just repeat it under 3.6F and 3.6G.
Agreed.
Okay. Does that work with you, Mr. Henderson?
Yes, sir.
All right, thank you, sir. All right. Okay. Moving now to the state's request for special instruction regarding withdrawing from physical contact, filed October 23, 2024. Court has reviewed it. I guess the first question is, what say, is there proposed language?
Trying to see if I'd actually put that in there.
I don't know that I see it, Mr. J.
Oh, paragraph 15. Physical contact includes any restraint on Jorge Torres, apostrophe, movement.
And this would be after the initial aggressor portion in the 3.6F and 3.6G, correct?
Yes, sir.
Okay, what say you, Mr. Henderson?
If I could have one.
Yes, of course.
Judge, this is what I'm having a problem with, but I think it can be corrected. Because they're talking about that there's Therefore, at the conclusion of the two paragraphs regarding initial aggressor, it should come in not there, but shouldn't it come in because that's not there anymore? Initially provoked.
Yeah, in the 3.6F instruction, references to initial aggressor have been removed.
Yes. So now is the state asking for it to come in as the initially provoked?
Unless I missed something.
My understanding was that it was the two paragraphs about aggressor are coming in. What's not coming in is the Martinez forcible felony. The facts of the case.
Right, but the language, you said at the conclusion of the paragraphs regarding initial aggressor, the words initial aggressor don't appear in the 3.6F. It's only after that. However, the use of deadly force is not justified if you find Sarah Boone used force to initially provoke the threatened use of force against herself unless, and then it's paragraphs 1 and 2. Is that where you're asking it to be?
Hold on, let me pull 3.
Sure.
You got it here. So in 3.6F, it should be, however, the use of deadly force is not justified if you find that Sarah Boone used force to initially provoke
Correct.
the
That's what I have.
use of force against herself unless, parens 1 and 2.
Correct.
And then after 2, as an explanation for what is listed in paren 2 as from physical contact, just that elaboration of what we're talking about.
I got it.
Because
Okay.
the unique circumstances of this case, the remote force.
Okay, I got it. I just want to make sure we're all on the same page as to where. What say you as to the proposed language of physical contact includes any restraint on Jorge Torres' movement as that portion in 3.6F and in 3.6G?
No objection.
Okay, all right, so court's going to grant the state's request for special instruction regarding withdrawing from physical contact. And the language of physical contact includes any restraint on Jorge Torres' movement will be included after the however the use of deadly force language after paragraph 2 in the 3.6F instruction. And in the 3.6G instruction, it will be at the end after the physical abilities section. Also, it's George is spelled incorrectly. That will be remedied.
I thought the 2 paragraphs about aggressor were being mirrored in 3.6G. It shouldn't go after physical abilities, it should go after...
Oh, I'm sorry. You're correct. I apologize.
No problem.
Okay, got it. That takes us now to the state's request for special jury instructions on causation, filed October 23, 2024. I have reviewed it and the proposed instruction on paragraph 3 therein.
Judge, the reason we're bringing this up is just during the cross-examination of Dr. Z, or Zadovich, we poked the bear a little bit about his cardiovascular condition. My memory of the testimony was that she's emphatic that that was not the cause of his death. But because of that, and because of now the request of culpable negligence at misdemeanor for a lesser, I feel it might be warranted to give this explanation of causation in the second-degree murder and manslaughter instructions.
Defense, what say you?
Judge, I would object. I believe that just the instruction, the proposed instruction that I have it, as one but for the defendant's criminal act, which we have a standard jury instruction that said the death was caused by the criminal act of the defendant, and that's what they're required to prove. This language, to me, would lessen that requirement by saying but for the defendant's criminal act. Then the second part, when it goes up to Jorge Torres' death, was not beyond the scope of any fair assessment of the danger created by the defendant's criminal act. I think that's covered, Judge, in the fact that the state does not have to prove that Ms. Boone had the intent to kill George Torres. So that makes it confusing to me when the standard instruction basically simplifies it, in my mind, and it keeps them right where they're supposed to be with that instruction. They don't have to prove that she had the intent. Then, as to the third part,
I'll withdraw my request for that.
Okay.
If heart disease gets brought up in closing, we'll do it.
All right, fine. So withdrawn. Court takes no action on the state's request for special jury instruction on causation. That leaves us now with the state's request for forcible felony instruction and request for initial aggressor instruction.
That's already
been addressed, has it not?
I was just treating it as a special jury instruction for my argument.
Understood. All right, are there any other instructions sought by the state at this time?
I believe we have concluded this exercise.
Defense.
no other ones.
All right, here's what I'm going to do. I'm going to take all this upstairs. I'm going to re-review it. I'm going to merge it all into one document, and I will send it to all the parties. Let's plan on being back here at 1:30, and we'll address any other concerns of the jury instructions at that point in time. State, anything else we need to address?
125.
Let's make it 1:20.
All right, thank you.
Defense.
Nothing else.
All right, we'll see you all at 1:20. Thank you. All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. Limited appearances for the state, please.
Dave Cacciatore on behalf of the state. Will J. for the state.
Defense.
James Owens for Ms. Boone.
Tony Henderson for Sarah Boone.
Coming back over there. Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from this morning. I apologize for my lateness. I realized that there were some typos after I'd sent this to print and needed to take them all apart to fix it. So thank you for your patience as we worked through that. State.
We noticed that in the non-deadly force,
Page 12.
there was a couple strike-throughs with the use.
I saw.
However, there was also a mistake with leaving a paragraph about reputation in at the very end of 3.6G, and that should have been a mirror of the relative physical capabilities of the parties.
I do see that.
Other than that, I saw the he/she bracketed still.
I fixed that on page 16.
And then it's just that one, I think, that Mr. Henderson and I noticed.
Okay, all right. I can have Madam Clerk start fixing them here.
Yeah, I think we should proceed and get going if we can.
But they will have nothing in their hands.
All right, well,
That's the issue.
all right, let's face that one, maybe.
Sorry. All right, thank you. Just give us a minute to fix all this. Yes, be fabulous. And just so that I'm clear back on the record, we're referring to the bottom of page 12, 3.6G, paragraph 2, where the use is struck through, correct?
Yes, sir.
And then we're referring to the top of page 13 as to that 2 lines as to reputation. Is that correct?
Yes, sir, that should be physical capability paragraph or sentence.
Let me pull back up to the 3.6G instruction. God. So that reputation paragraph should be removed in its entirety, and it should be the,
In considering the issue of self-defense, you may take into account the relative physical abilities and capacities of Sarah Boone and George Torres.
there it is. Thank you. Take it out. Yeah. 10, 12, and 13. Thank you. It is not letting me copy it over, and I don't know why. Correct. Was there anything else other than that? If you find George Torres had a reputation for being a violent and dangerous person, you may consider this fact in determining whether he was the initial aggressor. Anything else that needs to be added to the jury instructions from the state side of the ledger?
The reputation should be deleted.
Correct, I agree with you, yes. I'm sorry. What the heck is going on here?
No reputation, Judge?
That's correct.
What does that state exactly? Is that all here?
Mr. J, was there another line that we had added to the end of that?
I don't believe so. The physical contact sentence is where it should be.
Okay. Maybe that's what I was maybe that's what I was thinking of. So the sentence should read, in considering the issue of self-defense, you may take into account the relative physical capabilities and capacities of Sarah Boone and George Torres. Is that correct?
Yes, sir.
All right, thank you.
36F.
Correct. It matches 36F now. I apologize. I'm going to have Madam Clerk, I'll email it to her now, have her print out pages 25 copies of 12 and 13, and we'll start taking apart our jury instructions and re-adding them. And I thank you for your patience. 12 and 13, that's it. Mr. J, are you going to be utilizing the verdict form in closing?
I am not.
Mr. Owens, are you going to be utilizing the verdict form in closing?
I may. Where is it going to be at your bench?
Yeah.
I'll ask you for it if I need it.
Very good, sir. Thank you.
Judge, and when you get a chance.
No, go ahead, sir. I can multitask.
I know there's a mic here. I know there's a mic right here.
I will confirm with court admin that microphone is on. I believe it is. They turned it on during openings. I'll confirm now.
And then, Judge, last time I used this fingerprint table as my podium.
That's fine.
I may just slide it back so I'm...
That's fine, sir.
And then, Judge, I've got 2 tripods. And I've got some demonstrative aids. One is this, it was originally a quote by Dr. Michael Brannon.
Objection.
Okay. May proceed. What are the other enlargements, sir?
It's it's the one I tried to get in.
I hear no objection.
An opening, which was the justifiable use of non-deadly force.
No objection.
Those 2. And then, you remember my reasonable doubt? I was using it for...
You've seen them?
I
Okay.
had no objection to those 5. I didn't like the 3 charts. The defense agreed that the we found reasonable doubt charts they won't use, so I think we're all good on their charts.
All right, very good.
And the only other thing I'd want to use...
But we're good with their demonstrative aids during closings that we were used during trial.
Okay, very good.
I've got 2 videos that I'm going to want to play, and Shelby Andrews is going to walk up.
They're in evidence, right?
They are.
Yep.
We're going.
Okay,
One of them's been pared down.
that's fine. As long as it's in evidence, you can present whatever you'd like.
And Judge, do you want to talk about time for closing?
We can. What do you think, State? You advised an hour and a half.
Yeah, I think we both said hour and a half, but as the court knows, you can't really hold us to it until it gets a little ridiculous.
That's true. How much do you anticipate, sir?
Well, Judge, she's charged with murder. We've had a 2-week trial. I've got a lot to say. I've got a lot of notes.
We're good, let's go.
Say again?
I'm not hearing any,
Okay.
stammering clamoring from the state.
After the state has had their first opening, give them a short
Agreed.
break, and then let me start.
Agreed. We'll take our afternoon break at that point in time, then we can proceed with the defense closing and then rebuttal. I have received approval from the chief to work after 9 o'clock. So we can go till about 10, maybe a little bit thereafter.
And then you're saying with the jury? And
Correct.
then at 10 o'clock, if we hit some number, 10 or 11, then we would come back Monday?
That's correct. Thank you. State, are you ready to proceed?
Yes, Your Honor.
Defense, are you ready to proceed?
1 minute, Judge.
Yes, sir.
We're ready, Judge.
All right, let's go ahead and bring in our jury. Yeah, that would be fabulous. Just Bruce, come on up. I do not. The instructions to give the jury. Okay, thank you.
More continuing coverage in the suitcase murder. The trial of Sarah Boone is on the way. From the Hidden Killers podcast and True Crime Today. Press subscribe now.